if this book, before it had become a global sensation, had already helped thousands of women leave situations like Lily was in, I knew that if we could find a way to adapt it, which we knew wasn't going to be easy, then we had the potential to impact millions of lives. And that's why I'm in this business. Nothing against just popcorn movies, but I feel like for me, I want to touch people's souls. And this book and Colleen, it reached in and touched my soul. And I wanted to pay that forward.
Hey friends, it's Katie from Without a Crystal Ball. Welcome back to my channel. If you were nervous yesterday after Justin Baldoni and Wayfair Studios got a huge motion to dismiss filed by Blake Lively, and many of you were like, whoa, I was watching Stuart and Keith and they were like, this is a really good motion to dismiss. Yes, it was a well-pled motion to dismiss, but that doesn't mean it'll actually be granted. And filing a motion to dismiss in the front is something that people will do if they believe there's a shot of getting out of the case. Unfortunately, motion to dismisses for failure to state claims in this manner are very difficult to win. They're more likely to win on the front end if you have like a jurisdictional issue, a service process issue, or a legal issue. But stating a claim, that's a hard one to overcome. So I was feeling, frustrated after reading her motion to dismiss, but I also felt like a sense of like, I've gone through several lawsuits. So, and I've never lost one, by the way. And I know what it's like where I've actually filed a motion to dismiss. One I won and one I lost, right? And the one I lost was a defamation case and it's still ongoing. And I'm in the final stages of it. And I'm hoping that it'll get dismissed soon, like finally adjudicated after our summary judgment. But I know that these motions to dismiss are extremely hard to overcome when you're trying to get out of defamation. And it's because judges don't like to dismiss defamation cases when an actual defamatory statement appears actionable. And Justin has some actionable statements that very well could be litigated. So in this situation, I was feeling nervous, and a lot of you were feeling nervous, but you shouldn't, because today you should feel really, really hopeful, because earlier today, the judge gave a signal to Justin and Wayfair, along with Blake and Ryan and Leslie, that while he's taking these motion to dismisses and obviously will rule on them, he is not, I don't think, going to be inclined to order that they be dismissed. And it has to do with how he referenced Leslie Sloan's, or last week she asked them to pause discovery. She said that it would be, too difficult and arduous, and they had served her so many requests for production and all these requests for information, and that she felt it was overbroad and was so extensive. And the Wayfair people argued back that, like, listen, you got your AEO last week. If you think it's overbroad, come to us and do a meet and confer. But going over a stay of discovery would be way too much. And so today he ordered the motion for a stay of discovery is denied. See Robbins versus Candy Digital 2024. And it gives a date of May 15th, 2024, denying discovery to stay discovery. So he's basically telling them, like, listen, the reasons why I'm going to deny this are very similar to this one specific case. And then he said, to the extent that the discovery requests exceed the bounds of what is permitted under federal rules of Civil Procedure 26, they may move for a protective order. Okay, so what I did then is you pull up this order, which you can find over on CaseNet, and he said, defendants move from order staying discovery pending a decision on their respective motions to dismiss. The motion to stay discovery are denied. A motion to dismiss does not automatically stay discovery except in cases by private securities. Thus, discovery should not be routinely stayed simply on the basis that a motion to dismiss has been filed. Merely because these defendants filed an early dispositive motion does not in of itself give rise to justification to warrant a stay. And this was a quote from another case. And it also says, upon showing of good cause, a court may grant a motion to stay discovery pending a decision on a motion to dismiss. Um, they have to consider the breadth of discovery sought, any prejudice that would result, in the strength of the motion. Okay. And this is what he said. The strength of the defendant's motion does not justify a stay of discovery. Defendants Candy Digital, blah, 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 make a strong argument that the plaintiff has failed to plead a claim for unlawful interference and retaliation under Family Medical Leave Act. So this is a very similar case. It's a discrimination case and it's a retaliation case. And because plaintiff was not eligible for such leave at the time he requested it, and based upon that request, his employment was terminated. Defendants Fanatics also make strong arguments that the plaintiff was not sufficiently alleged that they were his employer or that a joint employment relationship existed. However, plaintiff makes strong arguments that document upon which the Candy Digital defendants rely is not cognizable on a motion to dismiss, that the court should not convert the motion to one for summary judgment at the onset of the case, and that in any event, the plaintiff would have been eligible for FMLA leave when he planned to take it, and that he unlawfully was terminated in retaliation for protected activity. So basically, what he did was he was looking at, okay, yes, they had a strong case here, and then the plaintiffs responded, and then he says, in response, the Fanatics defendants argue that he has sufficiently alleged an employment relationship and that any defects of his pleading can be cured by amendment. With a strong argument on both sides, defendants' arguments do not supply the requisite substantial grounds for dismissal or under the alternative formation articulated by Judge Gorenstein, and a strong showing that the party moving for the stay is likely to succeed on the merits. So basically, that they wouldn't dismiss the case, nor would they stay the discovery. It says, nor have the defendants shown that the breadth of discovery sought justifies a stay of discovery. So as far as like the arguments, he said, yes, you have a good argument for a motion to dismiss, but the plaintiff had an amazing response. And so just because you have a strong argument doesn't mean I'm going to dismiss this claim. And then he also said that just because they've asked for discovery, the amount they've asked for isn't that broad. It's a very narrow window of time, much like what they're seeking in this case, where the window is from August of 2024 till December of 2024, because that's when she says the smear campaign, the alleged one, started. So ultimately, he denied it. He had to hold on to the fact that a motion to dismiss does not stay discovery unless it's in the Private Securities Litigations Reform Act. So he's following the rules of this district, okay? So the discovery kept going, and then in December, he made a ruling on a motion for dismiss by one of the parties, a summary judgment from another party, and a motion to dismiss from another party. So in this case, it's a little bit complicated. It was like he's suing his employer for retaliation for taking FMLA, and there were two separate entities, one his direct employer and then this other company that sort of worked in collaboration with the company, but he was not an employee to and was not directly involved with. And so that company that didn't pay him, wasn't that he wasn't a employee to, and that really had no claim over him in terms of employment. Basically, his primary employer consulted with this other company about what they would do and if this is grounds for termination, and they got advice from that company, and then they made a decision to terminate him. And basically what the judge said is like, okay, we're going to dismiss the case against that company that they consulted, but we're denying the motion to dismiss against the company itself, and we're denying their summary judgment as well. But he also allowed them to file a amended complaint to overcome the issue of trying to tie the defendant, that's the one that was consulted, to his employer. So knowing that in the case that he just cited, and the stay of discovery was cited for that case where he ultimately denied the motion to dismiss and then also allowed a leave to file an amended complaint, kind of signals to me that this judge is very serious about this case, and that even though they want it to get thrown out in the beginning, that this is a judge that is very unlikely to throw things out that have very serious claims in them, and he is going to try to get these cases litigated instead of thrown out on a technicality. And I've noticed this in a lot of his filings that he is taking a very fair position here, that there are credible claims on both sides. Whether you believe the claims are credible on both sides is for you, the audience, to decide. But he is not taking this position that it's like Blake is the victim and Wayfair is the enemy, or that Wayfair is the victim and Blake is the enemy, right? Right now he's saying both sides have brought extremely serious allegations against the other. There is allegations of theft and sexual harassment. He's viewing very seriously Justin's claim of extortion. That's what it signals to me. And so this denial kind of tells me that he's serious about this case and it's not going to be something that's going to be thrown out easily. And if it is, he's going to allow Justin to file an amended complaint. So that's really good news for Justin, because yesterday I think a lot of people were feeling like, oh my gosh, Blake is going to get out of this because of Me Too, and she's going to weaponize this really new law that was filed in California that doesn't permit certain lawsuits to be filed. And, Brian Friedman gave a statement to TMZ after she filed the motion to dismiss. So let me just tell you what he said. He said this to People magazine. Miss Lively's recent motion to dismiss herself from the self-concocted disaster she initiated is one of the most abhorrent examples of abusing our legal system. Stringent rules are put into place to protect the innocent and allows individuals to rightfully defend themselves. Laws are not meant to be twisted and curated by privileged elites to fit their own personal agenda. He also addressed Ryan's request as well by saying, as we said yesterday in response to Mr. Reynolds' same cowardly measures, we will continue to hold Miss Lively accountable for her actions of pure malice, which includes falsely accusing my clients of harassment and retaliation. Her fantastical claims will be swiftly debunked as discovery moves forward, easily disproved with actual evidentiary proof. So, what we're seeing here in this case are two separate positions. Blake is trying to claim that, I was sexually harassed, and therefore I got nothing out of expressing these concerns to my employer forward. I only got more protection for the cast. It didn't get me anything else. I only volunteered and I got nothing out of it. But she did get the coveted PGA designation, which actually opens her up to receiving awards through the Producers Guild. Here's what my chat GPT said. The PGA designation stands for the Producers Guild of America and is a mark of distinction awarded to producers who have been officially vetted by the Guild. It signifies that the credited individual actually performed the full producing duties on a film or TV project rather than just receiving a courtesy or contractual credit. It ensures that the person credited as a producer truly played a hands-on role in making the project happen. So it's legitimacy and recognition. It makes you eligible for award. The PGA designation is crucial for determining who qualifies for major industry awards like the Oscars and Emmys. Gives industry credibility. It separates real producers from financiers, executives, and others who may receive a producer credit without actually handling the responsibilities. And it's a fair credit. It protects producers from being overshadowed by big name actors or directors who sometimes negotiate producer credits without doing the work. It's a stamp of credibility, ensuring that a producer was essential to a project's success. So that's a huge incentive she got, a huge credit. That's what she got for the extortion. So, there's what I saw with his response is that they're going to lean into this concept of malice, because he said she did this with actual malice. And they all said that Blake and Ryan and Leslie have said that he didn't meet the claims for civil extortion. And they kept citing criminal extortion. But the state of California has a civil extortion claim. And here's what S. House law says that you have to meet in order to prove. The defendant knew the threat was wrongful. The threat included a demand for money, property, or services. Money, property, or services. So it doesn't have to be money or property. It could be services. Property in this case could be PGA credit, or it could be giving her that access to this film, right? And the plaintiff and the property could also be the film, right? And then the plaintiff complied with the demand. So they have to prove that she knew it was wrong. that she demanded things, like she demanded that she get a cut of the film, she demanded that she get editing rights, she just demanded that she use, her cut of the film be released. She threatened that if they didn't release her cut according to them, that she wouldn't promote the film, and that you see in his case, they complied with every one of her threats, okay? So, an example that they list for civil extortion would be this: a woman threatens to accuse her ex-husband of domestic violence unless he increases his child support payments. Someone threatens to file a baseless lawsuit unless the other party agrees to settle. So, celebrity's ex-employee threatens to reveal confidential information unless the celebrity does the right thing. Interestingly, in their motions to dismiss, they kept saying a legal threat is not extortion. But in this explanation, it is, especially if it's being done under the pretense of obtaining something that they never would have gotten anyway. And they kept saying that they didn't do anything physical to fear or to cause fear. But they state that what level of fear is necessary. Fear such as will constitute extortion may be induced by a threat of any of the following: one, to do an unlawful injury to the person or property of the individual; to accuse the individual threatened or a relative of his or her or a member of his family of a crime; to expose or to impute to him, her, or them a deformity, disgrace, or crime; to expose a secret affecting him, her, or them; or to report his or her to the immigration status. So in this case, they're saying she was going to accuse us of the crime of sexual harassment and sexual assault. And if we didn't comply, she would go public with that. Blake's very first accusation and demand for this 17-point agreement came with a letter that basically said, if you don't sign this, I'm not coming back to work and I reserve my rights to sue you. That's not how you generally would handle a case of sexual harassment. And here's another point that's important that the same article references. What if the defendant had a legal right to carry out the threatened actions? People have a right to report wrongdoing to the police and government agencies and their company's human resources department and so forth. But just because you have the right to do something, it doesn't mean you have the right to demand money not to do it. For instance, people have a right to post negative reviews on websites such as Amazon and Yelp, as long as such reviews do not constitute business disparagement or defamation. That right is protected by the First Amendment. Likewise, people have the right to report a suspected crime, an immigration violation, or a violation of a company's sexual harassment policy. But when someone makes a threat to do one of those things and demands money not to do it, it is unlawful. So basically, her repeated threat to Justin and Wayfair, as per the evidence they've provided thus far, is that if you don't do this, or if you say no, I won't do this, or I will expose this, or I'll go to the New York Times, or I'll go and do this. I'm going to tell everyone about what you did. I'm not going to promote the film. I'm not going to talk to Taylor Swift. So she has a legal right to report that she was sexually harassed, but she doesn't have a right to use the sexual harassment claim to make demands for credit for PGA, to get rights to a film, to get a song in the movie, to promote a film. That's where it becomes unlawful under the statute. And to be clear, in her motion to dismiss, she claims that they only brought this extortion claim against her when she filed a lawsuit against them, and they never had issues with anything that she had done before. But they have an email that Jamie Heath sent in June of 2024 when she requested the PGA credit. And this is what he wrote to Wayfair staff. I'm writing to you all regarding the letter that I wrote on behalf of Justin and myself addressed to the Producers Guild. As you know, we received a request to write a recommendation on behalf of Blake for her to receive the PGA mark. This was a request that we feel was unreasonable and cold-hearted. Essentially, the movie IEWU has been taken unjustly from Justin as a director and essentially from Wayfair's control due to the extortion of Blake. So they were alleging extortion in June of 2024. Without going into the details of the events, that have transpired over the months, Justin and I ended up agreeing to write the letter due to feeling trapped. She continues to hold a threat over our heads, and every time we try to hold a line, she uses the threat either directly or indirectly to get us to fold. Make no mistake, I'm not suggesting that we are literally forced to acquiesce, but given the high profile of the movie, the partnership with Sony, the amount of money invested, and the need to complete the movie, we have written the letter on her behalf, omitting the truth of how and why she was able to contribute the ways we listed. There's nothing to do with the letter now. It only serves as a way to memorialize why the letter was sent. So they literally were preparing ahead of time. They were thinking ahead about this lawsuit. So Blake can't now say that they never thought about it before she sued. And I feel like she adds that in her public motion to dismiss because she wants people to forget that this letter was sent in June of 2024. And she wants them to just strike this timeline of relevant events because it proves the extortion. Under this explanation, they've met the blackmail penal code of civil extortion, in my opinion, because their case is she threatened that unless we did this, she wouldn't do that. And this is what she wanted. And this is what we did. And we complied. So I don't know how she overcomes that because she keeps saying that all she did was offer to help and she volunteered and that she just bullied her way in. But it appears they have a lot of evidence that she actually extorted them. And it'll be interesting to see how the judge handles the California laws, even though they're in New York. Because if you remember, this New York Times is arguing that they get the New York Shield law. And then Blake is arguing that she gets the Me Too law. But interestingly, that law only prevents retaliatory defamation claims if the claims are made without malice. So if they can prove that she extorted him, that will not pass the sniff test. And because this case is complicated, I can't see on the basis the judge being like, yep, I'm going to just throw it out. Because if he's wrong and she did extort them, this would send a huge precedent to like the public, like, okay, so anyone can make a baseless claim against anyone to get what they want, and they will be not held liable if they use this law. And this is such a visible case that I just can't see a judge being like, yeah, we're going to throw it out, because what if he's wrong? What if Wayfair has the evidence to prove that they are right? The only way that they can prove is going through litigation and going to trial. They can't prove it by deposing the case or getting rid of it early because they don't want it and she doesn't think that they can file it. So long story short, Justin got some good news today and I'm feeling better. There's so much more that we need to talk about today, but I don't want to keep this video specifically long. So let me know, what are your thoughts about that? Are you happy to see this decision by the judge? Are you glad to know that the case is likely not to get dismissed? Or if it is, he's going to be given an opportunity to amend the complaint? And what are your thoughts about all of it? Tell me in the comments below. Make sure to give this video a thumbs up. Also, please subscribe to my channel if you haven't subscribed and click the bell so you never miss a video. Thanks so much for watching. Bye, guys.